Good afternoon, everybody. Today we have the pleasure of hearing from Marcia Waters, the Director of the Division of Real Estate, and this is her second installment of the Directly from the Director series that's going to touch on important issues for the real estate broker community. Today's installment is going to cover transaction file requirements and retention and brokerage relationships and disclosures. Also, please note you are on mute, and we have surveyed questions in advance from attendees to respond to, and if we have additional time after the presentation, we can address more questions through the chat feature. We will be recording today's presentation, so you can also have the opportunity to review it later. Also attached to this webinar is a copy of the transaction checklist and the PowerPoint slides. I'll now turn this over to Director Waters, and thank you for joining in today.
Well, thanks for joining us. The way that this is going to work is we're going to do transaction file requirements first, and then we'll do questions and answers. And the questions are from the survey that we had you guys fill out, and then we'll move on to brokerage relationships. So with transaction file requirements, the important thing that you need to keep in mind is the individual broker and the brokerage firm each need to retain their transaction files for a period of 4 years. If you decide to retain them longer, that's up to you, but our requirement is 4 years. You can maintain them in hard copy format or electronic. If you maintain them electronically, what you need to be aware of is you just need to keep them in a way that if the division needs to access them, we are able to access them. So I know a lot of brokers use software for their contract forms. You need to be making sure that you still have access if you're using a platform for your contract documents, that you've got access for 4 years. So typically what we see in a complaint investigation is one broker will initiate the drafting of the documents, and then say like it's the buyer's broker that does the contract to buy and sell. And then the listing broker may have access to that software, but it's the buyer's broker because they created the document. They're the ones that really can maintain control over the documents. So as a listing broker, you would then want to download copies so that you have access in case that buyer's broker for some reason cuts you off as far as having access. We do see that come up from time to time with the complaints that we investigate. So individually, the broker has to maintain copies as well. A lot of you change brokerages. So if there was a complaint that came in that said like 3 years ago, Marcia did this, and the real estate commission asked me for my transaction files from 3 years ago, and I've changed brokerages, the real estate commission is not going to expect the brokerage firm to be submitting the documents to us. We're going to be expecting the individual broker who's got the complaint against them to submit the documents. So that's why we have made it a requirement for both the individual broker and the brokerage firm itself. So with the 4-year records retention, we have also put together a transaction file checklist, and we've got checklists for sales files and also for property management. And there's an attachment for this meeting so that you can see those checklists. Those checklists are to serve as a guide for you. Each transaction is unique, so not necessarily everything on the checklist that we've got on there is going to be applicable to your transaction file. For instance, like a letter of intent, those are typically something that is used in a commercial transaction. So if it's a residential sales file, we're not going to be looking for a letter of intent. Likewise, depending on what the market's doing, sometimes a broker will do a licensee buyout addendum. You've got a seller that needs to sell because they've got another property under contract that they need to close on, and if the market is one where, you know, it's really more of a buyer's market than a seller's market, then your seller may be in a position that they need to sell that property quickly instead of waiting for a buyer. And a lot of brokers, I know back in the early 2000s, would do licensee buyout addendum. So in that type of scenario, we would expect to see a licensee buyout addendum. Or if you've got a seller that is going to be living in the property for a while after the transaction closes, if that's the scenario, then we would expect to see a post-closing occupancy agreement. So you really need to bring your A game when you're dealing with transaction files, because we're going to be looking for the documents that are germane to your transaction. It's not necessarily going to be everything that is on the transaction file list. But that is to serve as a guide for you. And at some point, we'll probably be putting together a checklist for leasing transactions, since there is a little bit of a difference between leasing and property management. So with that, Pat, are you ready to move on to the individual questions that we have?
You bet. Thanks, Marcia, and thanks for those brokers who took the time to provide us with some questions when you signed up for this webinar. We're going to start with those. If you have additional questions, feel free to add them here, and we'll get to them if we can, but we want to be respectful of the hour that you have dedicated to this. So, Marcia, one of the questions that we've gotten is, while text messages and emails are not necessarily on that checklist of required documents, what are your thoughts about brokers retaining those emails and texts?
So I definitely would retain those in your transaction files. That has been kind of the saving grace for several of our brokers that have had complaints filed against them, because they've had the correspondence with their client or another broker memorialized in writing, and then that way they've actually got physical proof to show us. You know, if you've got a buyer that says, no, I don't want to have an inspection done, if I was that buyer's broker, I would be basically confirming in email, I just want to confirm with you that you don't want to have an inspection done, because I will tell you more often than not, when the buyer moves into the property and finds out that there's issues, their failure to get the inspection done is getting blamed on the real estate broker. So that email chain can really save you from falling into hot water based on a complaint that we get.
And another question that we got asked, when you are supposed to retain transaction files, what actually constitutes a transaction? So for example, if somebody takes a listing agreement, but the transaction never closes, that property never sells, are they expected to retain all of that information from the listing period?
So that listing agreement is a contract. So we do expect you to retain those files as well. And then anything that goes along with that listing, even if it didn't sell, you still have a contract there. So we expect to see that file if you get either selected for an audit or a complaint comes in.
And sort of a similar related question, if, for example, a listing broker gets multiple offers in, even though only one of those offers will lead to the transaction closing, what is the expectation for keeping or not keeping the multiple offers?
I would still retain copies of those multiple offers. And the reason that I would tell you to do that is one of the common complaints that we get is that the broker didn't present my offers. So if it's in the file, that just kind of lends to, it does appear that the broker did present your offer to the seller, it wasn't selected.
And another person has asked, sort of again, on a similar vein, if I'm the buyer's broker and I have submitted multiple offers, should I keep the offers even if we didn't win that bidding war?
Yes, you should.
And any thoughts on what to do if the documents have not been retained? Any thoughts on how they should try and get those documents back?
So not having your files for the 4 years usually comes down to a couple issues. One, you may have, if you were maintaining them electronically, your computer may crash. Or there's the ones that are not complying with the requirement to retain those documents and you just haven't done it. So to the best of your ability, if you're able to recreate that file, which if it's a consummated sales transaction, one of the ways that you can do that is reach out to the other side of the transaction and see if they can give you a copy of the contract to buy and sell, any amend extends or addendums that were included. That way you can recreate it. Otherwise, if you can't recreate it, just don't have them. I would hope and pray that we don't randomly select you for an audit or that there isn't a complaint filed, because that's typically the two scenarios when we're going to be asking you for your transaction files. With that in mind, there's 48,098 real estate brokers in the state of Colorado. So your odds of being selected for a random audit are probably pretty low. However, if you're like me and your life is Murphy's Law, if I didn't have my transaction file, I would probably be number one on the commission's audit list.
And do you feel one of the brokers has asked if it's safe to then delete them after 4 years, or is there any reason to retain them for longer?
Well, the commission's requirements are 4 years. What you also need to consider, and this is when you would be consulting an attorney, is if there's litigation involving that transaction. And if there's pending litigation or active litigation, you shouldn't be destroying those documents anyhow. But beyond the 4-year time span, that's really up to you as far as whether you want to retain those. One thing to keep in mind is, unlike the criminal statutes, which most of them have a statute of limitations, our statute of limitations on investigating a complaint against you go back to the inception of the Practice Act. So for real estate brokers, licensure was created in 1925. So if somebody wanted to file a complaint with us about somebody that screwed up on a transaction in 1930, technically we can investigate that. It's going to be a little difficult to go that far back, and chances are nobody's going to have transaction files that far back, but just keep that in mind. Hopefully, when you're dealing with people and you're dealing with somebody who you think is going to be problematic, you're going to be able to identify that. But I also know that a lot of our respondents, who are the ones that get the complaints filed against them, a lot of these complaints are kind of filed out of the blue, and it's by people that they think are happy with their services. So whether you want to retain them beyond the 4 years is completely up to you, but definitely if there's litigation involved, that's when you should be consulting an attorney as far as how much longer you should be retaining those files.
So then are you saying that, for example, we could get a complaint today for a transaction that happened in 2014 and we would still investigate it?
Yes. So when I started with the division back in 2005, one of the complaints that I was assigned stemmed from a soured business relationship in the 1970s. So we still had to do the investigation. And the thing that you should also keep in mind is if it appears that we have jurisdiction, the license law actually requires us to investigate. So we can't just say, well, this happened 30 years ago and they don't have to keep their files for that long. We still have to do an investigation.
And if someone is either being audited or there has been a complaint filed against them, what kind of time frame do they have for producing those documents for us?
Well, it may be a little different with the audits, but for the investigations, you've got 3 weeks, 21 days in which to respond to a commission complaint. With an audit, it's really just going to depend on kind of the depth of the audit as far as how much time you're going to have to produce those records. But notification of a complaint or being selected for an audit, that is not the time to put your transaction file together. You should have your transaction file together as you're going through the transaction. And then if it's one that closes, I mean, definitely that's when the entire file should be totally complete. Don't wait until you get selected for an audit or have a complaint filed against you.
And one of the brokers has asked, their office policy manual actually calls for additional documents that are not on the division's transaction checklist. Are they then required to keep those additional documents?
So we're going to look at the ones that you're required to have as far as the commission approved forms, and then also the commission doesn't create every form that you may need for a transaction. So we're going to look and see if you have those auxiliary forms in your transaction file. If there's something that's required by your office policy manual that isn't required at the commission level, just because you didn't have a disclosure form that your brokerage requires doesn't mean that that's going to run you afoul of the real estate commission. But what we are going to look at with those additional forms is what type of form are they and who created them. Because if it's a contract document like a lease or a property management agreement, then we're going to look and see if you've got the required disclosures that are required under the standard forms, statute and rules as far as, number one, it has to be drafted by a licensed Colorado attorney. Does it have the attorney's name on it? And does it identify the client of the attorney? Or is it a disclosure document? And technically, under the standard forms definition, a real estate broker can create a disclosure document, but that's where competency comes in. So if you draft a horribly bad disclosure document, while technically you could do it under the standard forms definition and the statute and the rule, if you do a really bad job at it, then the real estate commission can look at your competency. So just, I always caution the brokers as far as if you're going to create your own disclosure documents, make sure you do a good job, because the commission can look at you from the standpoint of, did you do it in a manner that was unworthy and incompetent?
And kind of on a related note, we've had a question about if they've been having people fill out a COVID disclosure, should that be retained as part of their transaction file?
Well, if it's part of your transaction, it should be in the file, but we're also going to be aware that that's not a commission approved form. So again, we would look at how is the document used and who created it.
And we probably need to move on to the next topic, but just as kind of a wrap up of this topic, we continue to have a couple of questions. So are you saying that both the broker themselves and the brokerage firm needs to retain copies of the transaction files for 4 years?
Yes.
Okay, just so everybody got that message nice and clear. So we have some questions on brokerage disclosures, but we'll handle that after your part of the presentation.
So now on to brokerage relationships. So Rule 6.6 addresses the different types of brokerage relationships that you can have. There's the listing contract by the individual associate broker. There's a listing contract by members of a team. So I think one of the important things that you need to keep in mind if you're going to be a member of a team is any time that you do a listing contract as a team member, you are basically binding the entire team, and the entire team should be identified on that contract. The other thing that you have to keep in mind is, and I realize that teams do not function all the same way, some of them kind of operate like mini brokerages within the larger brokerage. And so on this team, you may have brokers that function on behalf of the buyers, and then you've got other ones that specialize in dealing with the sellers. But you're all part of a team. So you cannot be, as a team, you cannot be a single agent for a seller and a single agent for a buyer in the same transaction, because essentially then the team is functioning as dual agents, and that's not allowable. So, but as far as brokerage relationships are concerned, a real estate broker can function in one of two manners. You're either a single agent or you're a transaction broker. And a single agent owes the utmost good faith, loyalty, fidelity to their clients. So you are their advocate. Both a single agent and a transaction broker are required to exercise a reasonable skill and care. So as a transaction broker, you're not the advocate, you are a facilitator in the transaction. If you're going to be a single agent, that's got to be a written agreement, and that's why you've got the exclusive right to sell contract or the exclusive right to buy contract. A transaction broker, you may still have a listing agreement that is in writing, but you're designating that you're a transaction broker. And if you're a transaction broker for a buyer and they don't want to sign an agreement, you don't have to have an exclusive right to buy contract. But that's when we're expecting to see that you have done a brokerage relationship disclosure to make it very clear to that buyer that you are functioning as a transaction broker. Gary, do you want to go ahead and move on to the next slide? And also the other important thing that you need to keep in mind when you're dealing with a brokerage firm that has more than one broker in it. So if I'm a broker associate and I work in a firm with 200 brokers, if I take a listing agreement and I agree to be the seller's single agent, the seller's agent, that's my designated brokerage, is as a seller's agent to that seller. that doesn't extend up to my employing broker, even though my employing broker is responsible for supervising what I'm doing. And ultimately, the listing contract belongs to the firm, but I am the designated broker for that transaction. And the employing broker can switch out designated brokers if that's necessary. So when you're functioning as a transaction broker, you can be a transaction broker for one side of the transaction or a transaction broker for both sides of the transaction. And also, what you need to keep in mind is you can function in different capacities for different transactions. So if I am a seller's agent in the sale of my seller's property, I could be a transaction broker for that same seller in the purchase of a property for them. So keep that in mind as well. You can change lanes depending on which transaction you're functioning in and how they want you to function. Now, if I'm a single agent for my seller and there's an unrepresented buyer that comes in and the seller has authorized me to revert to being a transaction broker to cover both sides of the transaction, I'm allowed to do that. I'm going to need to do a change of status disclosure with my seller, though, if that buyer wants me to represent them as a transaction broker. And I don't know that I'm necessarily following along with the slides so much, but why don't we go to the next one? Okay, so single agent versus transaction broker. I kind of already covered this, but a single agent is an advocate. A transaction broker is there to facilitate the transaction. So the standard of care is higher for a single agent just because of the fiduciary duties that they have. But with both of them, like I said earlier, we expect you to exercise reasonable skill and care when you're functioning both as a transaction broker and as a single agent. The change of status disclosure is required when I am a single agent for one side of the transaction, and then another side of the transaction comes in and they're unrepresented and they want me to serve as their transaction broker. If my seller or buyer, who I have single agency with, authorizes me to revert to transaction brokerage, then I'm going to do a change of status disclosure, and I'm going to do it no later than when that contract to buy and sell has been executed. Next slide, Gary. So a lot of the questions that come up particularly when we go out and do our audits of your transaction files is, how are you supposed to be disclosing? When are you supposed to be disclosing? And what is disclosed? And a lot of people seem to think that you have to have the definitions of working relationships in all of your transaction files. The definitions of working relationships are to be used when you don't offer the different brokerage relationships. So if I work for a firm that only offers single agency, I am going to let anybody that I'm going to work with know that while we are only single agents at this firm, there is another relationship that is available. It's called transaction brokerage. And if they ask for that, that's when I'm going to give the definitions of working relationships so that they can figure out whether, maybe I do want to work with a transaction broker. And because this firm only offers single agency, then I probably need to go to a different firm that offers transaction brokerage. So it's when you don't offer all of the brokerage relationships that's when the definitions of working relationships comes into play. Then you've got the brokerage disclosures, and those are used anytime you start having discussions with a consumer and it goes down the path of collecting confidential information. So you're going to need to make that brokerage disclosure before they can reveal any confidential information to you. And so we've got the brokerage disclosure to seller. You're going to use that in a for sale by owner transaction where you're representing the buyer. You've got the brokerage disclosure to landlord, the brokerage disclosure to buyer, and the brokerage disclosure to tenant. So if I was, say like I was the seller's agent and I was holding an open house and I've got unrepresented buyers coming in, if they start asking me, what's the square footage of this property? If it's got acreage, can I have horses? Well, that's not confidential information, so that doesn't trigger the need for me to do a brokerage disclosure to them. What is going to trigger that disclosure is if they start disclosing to me, you know, this is how much of a loan I qualify for, this is my motivation for buying. Before they start disclosing that, that's when I need to do the brokerage disclosure. And depending on what type of relationship I have with my seller, that's going to reveal to them that while I'm a single agent representing the seller, I will be treating you as a customer, or in the case of a transaction broker, it will disclose to them that if that's the type of relationship that we've established, that I will be their transaction broker. There is something that you need to be aware of, and this was a rule change that came about from last year's rule review as far as transaction brokerage is concerned, though. So if I am a transaction broker for the seller or I'm a transaction broker for the landlord, you're going to have a listing agreement even to be a transaction broker, because that is going to lay out the terms of that sale or of leasing that property, which is not something, this is a change that we've had because it doesn't come up very often. But if you're a transaction broker for the seller, it is just not sufficient to say, well, I'm a transaction broker, so there's no listing agreement, because we're going to start wondering, how did you memorialize the terms of that sales transaction or that leasing, or if you're a property manager. So keep that in mind. About the only time that we would expect to see a brokerage duties disclosure for a transaction broker is if you're representing the buyer, where that's the one carve out where you're not going to have that written agreement under the current regulations. Now, if you are called up and the consumer says, please come over to my house, I'd like you to do a listing presentation, and they haven't disclosed any confidential information to you at that point, and you sit down and you do the listing presentation and they still haven't disclosed any confidential information, and they decide to sign the listing agreement with you, that listing agreement suffices. You don't then have to do the brokerage disclosure, because that disclosure is contained in the listing agreement itself. But we have a lot of people that are hesitant to sign a contract right out of the gate with a real estate broker. So because they may be having those conversations with you and potentially disclosing confidential information, that's when we're going to expect to see the brokerage disclosures. Gary, do you want to go to the next slide? So I've already pretty much, I think, gone over these. You can either be a single agent or a transaction broker. If you're a single agent, the other side is treated as a customer. You can be a transaction broker for only one side of the transaction. That is appropriate as well. And in that case, the other side would be treated as a customer in that situation. Or if you're representing both sides of the transaction, you're functioning strictly as a transaction broker. You cannot be a single agent for one side and a transaction broker for the other side. Colorado does not allow that to happen. Next slide, Gary. So Pat, are you ready for the brokerage relationship questions?
We have a ton of brokerage relationship questions. So yeah, let's dive in. And just as a note for the folks who are joining us, we have had some questions that have been presented ahead of time. You're welcome to add some questions and we'll try and get to those if we can. This is being recorded and will be available afterwards, and we'll have a list of frequently asked questions that you can refer to at that point as well. But maybe let's just start with the very first opportunity, for example, in an open house. So if, as you suggested, when they're asking questions, if a buyer comes into an open house that the broker is hosting and they're asking questions that are fairly general and are public information, it sounded like there was no brokerage disclosure that was required at that point. Is that right?
That's correct. If it's strictly factual, like what are the HOA dues, what's the square footage, that doesn't trigger the need to have to disclose the brokerage relationships.
And so then if that person that's visiting the open house then starts to say, hey, my motivation is, I got a new job and I need to move right away and I'm willing to spend $300,000, is just handing them a brokerage disclosure, is that sufficient delivery?
So I would expect there to be an explanation as well, because brokerage relationships is not something that the public really understands. And most of the time, when they have a complaint against a real estate broker, they don't understand the difference between a transaction broker or a single agent. They feel that if you're representing them, they think that you're their advocate, whether you are or not. So there is some explanation that needs to go into that. And particularly if you are a single agent and they start disclosing, you need to be letting them know, listen, I represent the seller. I'm not here to represent you. They need to be fully aware that they could be compromising their own bargaining power based on what they may be disclosing to you.
And is there some guideline for who you could be a transaction broker for? So we've had questions like, can I be a transaction broker if somebody in my family is buying the house, or if my friend is buying the house?
So while we don't have a regulation that specifically prohibits that, I have yet to see the Real Estate Commission not take action against a real estate broker when they are attempting to represent a member of their family, a long-term friend, or a long-term business partner as a transaction broker. You've got a conflict of interest there, and you should be representing those people as single agents if you're going to represent them. Sometimes, and this is one of the things that is kind of contrary to what they teach you when you're coming into the industry, because they really teach you to target your business at your friends and family. And I will tell you that from working at the division, if I went out tomorrow and activated my license and I had a family member reach out to me and say, hey, would you represent me in this transaction? Based on what I've seen at the division, I would refer them to somebody else that they are not related to, because friends and family are the first ones that are going to file a complaint with us when they feel that you have screwed up their transaction.
And we've had questions about, can I be a transaction broker if I'm a part owner of the property, for example, that's being listed?
No, you cannot. You are a single agent for yourself. So if I were to activate my license tomorrow and put my property on the market, and say like the commission selected me for an audit and selected my personal transaction, which they have the authority to do, then when we're looking at that transaction file, I would expect to see an exclusive right to sell contract, because I am my own single agent, and single agency requires a written agreement. So what you need to be evaluating whenever you're looking at potentially being a transaction broker for somebody is your conflicts of interest, or even a perceived conflict of interest. So, you should not be a transaction broker for a friend, and you shouldn't be a transaction broker for a business partner.
And so if I'm the listing broker, and I've been advertising the property, and then it turns out that my friend wants to buy it, what can I do then?
So if you're the single agent for the seller and your friend is the buyer, your friend needs to get their own broker to represent them in the transaction. I would also be disclosing to my seller that, hey, that buyer is a friend of mine, but I need to be very carefully making sure that I am complying with the requirements of being a single agent and I'm acting as their advocate. As a broker, I would be concerned that any misstep that I may make, that could be potentially perceived by the seller as me somehow compromising their position with that buyer who is my friend.
And if, for example, I'm the listing agent, I'm a single agent for the seller, and I meet a buyer at an open house, I don't know them, they're not a friend, they're not a family member, how would I notify all parties if I'm going to revert to transaction brokerage?
So then you would do the change of status disclosure, if that is what your seller has agreed to let you do, as well as disclosing your brokerage relationship to the buyer ahead of time, because you're going to have to disclose to them that I'll be your transaction broker, but you'll do the change of status disclosure, and you will do that no later than the signing of the contract to buy and sell.
And so we've had a little bit of confusion about when you're part of a team. So maybe if you could go over that again. If I am part of a team and I'm holding an open house, and one part of my team has determined that we would be an agent for the seller, what are my obligations in terms of my relationship with that seller and or that buyer?
So if that listing was taken as part of that team, that listing binds all of the team members to that designated relationship to the seller. So you would all be included on that listing contract as the designated agent for the sellers. So if you had, if Pat, you were the team member that took the listing, but I was part of your team and I was holding an open house, those buyers that come in, if they start asking me questions that leads me to believe that they're going to go down the path of concealing confidential information to me, I need to be disclosing that I am part of that team and that team is the seller's agent.
And so then I could not be a buyer's agent.
No. The one thing though with the teams, and I know that we've got the regulation, the teams don't always function. One of the things that we kind of grapple with, and I know that it's not just Colorado, this is an issue across the nation where teams come into play, is not all teams function the same way. So that's where we're going to be, if a complaint were to come in, we were going to be looking to see, how was the listing taken? Was it taken as an individual broker or was it taken as the team? And if it's the team, based on our regulations, then that contract binds the whole team. If it's the individual broker, then it's just that one broker.
And if it was taken for the team, would all of the team members need to be listed on the exclusive right to sell?
Well, they should be, although I know a lot of the times it just says like the Waters team or whatever, and that's going to lead us back to asking who's on the Waters team, and that's a question that we could pose to the employing broker as well.
And then we have a property management question. Is it appropriate to use a brokerage disclosure to tenant to include that as part of the rental application?
So what that's going to fall back on, though, is did you have a discussion with them and make it very clear what your brokerage relationships were? Just kind of throwing that document out there and expecting them to understand it isn't sufficient. You're going to have a dialogue with them to explain those brokerage relationships and how you are representing the different parties in the transaction or not representing the different parties in the transaction.
And so if I am representing the buyer and the buyer wants me to present an offer on their behalf, but they are not willing to sign an exclusive right to buy, is that legal and appropriate for me to submit that offer on their behalf?
Well, so then you would be functioning as their transaction broker. So you would be doing the brokerage disclosure to buyer, letting them know that you're functioning as their transaction broker. Now, if they're not wanting to have any sort of relationship with you, I would not be submitting offers on their behalf, because if they're telling you, I don't want you to be my broker at all, I don't want you to be my single agent or my transaction broker, well, we don't have the non-broker status. So you're one or the other. So if they don't want to sign a listing agreement with you, you would be a transaction broker if you're writing that offer. And then that pulls in all of the brokerage duties under transaction brokerage that you have to then be fulfilling.
So if they just want me to write the offer and then walk away, am I allowed to do that?
No. You have to perform all of the duties under transaction brokerage for them. If they just want an offer written, they can contact an attorney.
And do you, we've got a couple questions about whether or not there are additional risks or liabilities to being an agent, a single agent versus a transaction broker.
Well, so a single agent is held to the higher standard. You've got those fiduciary duties of, you've got to practice with the utmost good faith, loyalty, and fidelity, and that's what you're held to, along with exercising reasonable skill and care. Now, on the legal side, as far as whether there's more liability of being a transaction broker or a single agent, That's not something that we look at. What we're looking at from the Real Estate Commission's perspective is, did you fulfill the duties of being a single agent? Or if you're a transaction broker, did you fulfill those duties? And what you need to keep in mind is, so your required uniform duties are the ones listed under being a single agent or listed under being a transaction broker. You don't get to pick and choose which ones you are or are not going to perform. Those are the minimum that you have to perform. You can agree to take on additional duties beyond those, and that needs to be done in writing, but you don't get to pick and choose. And that's where we start to see those brokers that are entry-only brokers, where they're only going to put your property in the MLS and that's it. Colorado law doesn't allow that. You have to perform the uniform duties for whichever relationship you have established with your client.
And I think this question comes out of the MLS, so I don't know that we have an answer for them necessarily, but one broker has asked, what's the purpose of offering different commission percentages for a transaction broker as opposed to a single agent?
So I think what that stems from is, at one point, I think there was some legal advice given to, and I don't know if it was members of a certain realtor board or what, because I think it was more prevalent kind of in the southern portion of the state than in other parts, where there had been legal advice given saying, you know, you should pay a different percentage to a buyer's agent versus a different percentage to a transaction broker. I know from my perspective, as far as just working at the division, I don't really see any need for a disparity in the amount that is paid, because if you end up being a transaction broker for both sides, you're doing double duty. So I don't know why you would want to pay them less than you may pay a single agent. But I think that all stems from, there was some legal advice, and I don't even know what the reasoning was about why one should get paid a different amount than another.
Okay. Does the division have a position on how much anybody should get paid?
We don't. And please do not sit around and discuss like, well, I get paid this amount, what do you get paid? Because that will take you down the road of having to deal with the feds, because that's a violation of the Sherman Antitrust Act. So not a pleasant experience that I'm sure none of you want to go through. So definitely do not sit around discussing what commissions you offer.
And can you comment on how brokerage relationships apply to commercial deals for both sale and listing?
Well, they still apply. You're either going to be a single agent or a transaction broker. I think what you're going to see probably more often than you will residential is the concept of kind of an open listing, where you have multiple brokers that may be working on one property, and then whoever gets the purchase offer, that's the broker that gets paid. But brokerage relationships still apply to commercial brokers.
And how about, can you speak just generally to how brokerage disclosures relate to property management transactions?
So what we're expecting to see if we come out and audit a property management file is, with your management agreement, we expect to see the brokerage duties addendum to the property management agreement in your transaction file, and that's the document you're going to use to make the disclosure. But again, brokerage relationships still apply. You're either a transaction broker or you're a single agent, either for the landlord or the tenant.
And is there a difference, I'm kind of bouncing around a little bit, I apologize. Is there a difference between co-listing a property and being on a team?
So co-listing is something where that's typically occurring outside of a team. It may be two independent brokers. And say, like, I'm going to take a listing, but I'm aware that I'm going to be out of town for, an extended period of time, maybe while this property is listed, and I need somebody to cover it. I may sign up with another broker to co-list it for me, so that is covered.
And in that case, both brokers should be listed on the listing agreement?
Yes.
Okay. And does the seller have the right to say, no, I don't go for that?
Yeah, if the seller doesn't want to deal with two different brokers, that's the seller's prerogative.
And a broker has asked if they only work as a transaction broker, are they required to disclose that when they go on the listing presentation?
So they need to be disclosing that, and that's when your definitions of working relationships are going to come in, so that the consumer can then understand, well, what's the difference between a transaction broker and a single agent? I have heard, so kind of on that vein, I have heard brokers say before, and this is completely not accurate. I have heard brokers tell a consumer, hey, if you don't want to sign an agreement, that's fine. I can still represent you the same way, even if you had signed one. That's not accurate, because if you were asking them if they wanted you to be you were going to be their single agent, a transaction broker is not the same as a single agent, and you should not be representing that just because they don't want to sign a contract, you're still going to represent them as a single agent. You're not. You're going to be a transaction broker.
And so is there a problem then if I understand you right, you're saying that if they are acting as an agent, but have a listing agreement signed that says that they're a transaction broker, is that a problem?
So the commission still finds you a violation of the brokerage relationships, because there is a difference between the two. The single agent has fiduciary duties, and I mean, they're the advocate. The transaction broker is a facilitator. They don't have fiduciary duties. So chances are, if you do that and we get a complaint and we are able to substantiate that you are acting as a single agent, but under an agreement that shows that you are a transaction broker, I would expect that the commission's probably going to make you take a class in brokerage relationships so that you learn the difference.
Okay. And so in the case, this is a question from the broker, in the case where I have a signed listing agreement with the seller, and we have checked the agency and less relationship with both, and then a buyer with whom I have a relationship wants to buy the home, does the seller have the right to not allow me to revert to transaction brokerage?
Well, if they agreed at the beginning to allow you to revert, I mean, that was the agreement that was made. Now, if they check the box of you're only going to be a seller's agent, then they can put their foot down and say, absolutely no way can you be a transaction broker. But if they've already agreed to it, that's going to put you in a difficult position, because if you've agreed to be the transaction broker for the buyer, and you've also got your listing contract that shows that you were allowed to be a seller's agent unless a brokerage relationship with both, you're allowed under the terms of that contract to be a transaction broker for both. So if they wanted to complain with us, you wouldn't get into trouble for that.
And if I'm bringing a buyer to a for sale by owner, are there, I think you've already addressed, are there disclosures that I would have to provide to the seller? And what risks do you think are involved there?
So when you're dealing with a for sale by owner, you're going to have to do the brokerage disclosure to seller, letting them know that you are representing the buyer. And I do think the risk that you're going to encounter, though, is if you have an unsophisticated seller, chances are you are going to have to very carefully walk the line of representing the interests of your buyer and dealing with an unsophisticated seller who may need more guidance, which, you know, is why you enlist the help of a broker. So you're going to have to deal with some of that, because they may not be prepared to maneuver the deadlines. If you have inspection issues, how they deal with that. But you do need to make sure that you're not crossing over that line and representing them when you're not allowed to. It's the same thing, though, if you're representing the sellers and you have a buyer that comes in and they're not represented and they don't want to be represented. It puts the brokers in a really difficult situation. It's not it's not that you aren't able to perform the duties. You just have to be careful, because at some point you may have your client thinking that, well, okay, so you're representing them now rather than me.
Are there specific questions that you would steer clear of if you were representing a seller as a single agent and a buyer as a customer?
Well, the questions that I would be steering clear of, you don't want to answer anything that's going to compromise your seller's position on the sale of that property. So you wouldn't be disclosing any confidential information about like their motivation to move, how much they're willing to accept. Those are things that you need to keep closely guarded, because that is going to compromise their position. But there are things that you have to disclose. So if that property has a material defect, you've got to be disclosing that. So just keep that in mind as well. On the buyer side, if I was the buyer's broker, I likewise would not want to be disclosing to a seller their motivation for buying, how much they're willing to spend. But like with the seller's broker, there are material facts that I would have to disclose. So if I had a buyer that didn't have two nickels to rub together and they were not going to get qualified for a loan, but I'm out showing them properties and they want to submit an offer, I should be disclosing to that seller they don't have the financial means to consummate this transaction. That's a material fact that I'm able to disclose.
So in the scenario where I'm a seller's agent, and I'm treating the buyer as a customer, would I be allowed to ask that buyer whether they're pre-qualified and ask them for financial information to confirm that?
So if you've made the disclosure and made it clear that you are the seller's agent, I mean, there's no prohibition on what you can ask. But they need to be put on alert that you're not representing their interests. So you can ask them how much they pre-qualify for or how quickly they are looking to purchase. Because you're fulfilling your advocacy duties to your seller, you're boosting their bargaining position with whatever information you're getting.
And so if that's the case, then would I got audited or there was a complaint about that transaction, would I have to have something that demonstrates that I said to this buyer customer, hey, I'm not representing you?
So that's when we would expect to see the brokerage duty or brokerage disclosure to buyer showing that you are the seller's agent.
Okay.
And hopefully they've signed it. And I realize as we go out and do file audits, a lot of the times people refuse to sign the document because they don't know if they sign something, is it somehow binding them? Hopefully they will sign the brokerage disclosure, but if they don't, all you need to do is indicate on that form that you had presented it, but they refused to sign, and I would date it.
Okay. Friends and previous clients frequently ask me to write a contract for them when they are selling an unlisted property to another friend, a neighbor, or a family member. These are cases where the buyer and seller have already negotiated a price prior to my involvement. They make this request expecting a nominal fee for my services. In a case such as this, can I function as a transaction broker?
Well, they're your friends, so you should be a single agent. And I will tell you, this scenario comes up from time to time in our complaints where basically, and you kind of touched on it earlier about, well, can I just write an offer? Okay, so you're just going to complete a contract document, but you're not going to perform any of the brokerage duties. When we start to see that type of behavior, what it makes the commission consider is, are you engaged in the unauthorized practice of law? Because all you're doing is a contract document. You're not fulfilling your brokerage duties. And so if that is the scenario where all you've done is drafted the contract or filled in the blanks and checked the boxes of the contract, and you've performed no other duties. So the lens that the commission is going to view that from is, okay, you failed to perform your brokerage duties. And if you don't have an exclusive right to sell or exclusive right to buy contract, automatically, from the commission's perspective, you were you revert to being a transaction broker. So they will say that you've failed to perform your brokerage duties as required for being a transaction broker. Then, if it's really bad, what they may do is refer you over to the Supreme Court, because the Supreme Court is the body that has jurisdiction over the unauthorized practice of law. So if it looks like you were functioning as an attorney and you don't have a law license, the commission can discipline you, but then we can refer you over to the Supreme Court and they'll do whatever they feel is necessary.
That sounds scary.
Not just for the contract.
And so I get the impression from this person's question that maybe they were willing to, like the negotiations had already happened, but they were willing to help make sure the dates and deadlines are met and work with the title companies, but they had a close relationship with both parties, both the sellers and the buyers. Any thoughts on what to do then?
So if you've got a close relationship with both, I mean, close relationships, you should be a single agent, and you can't be a single agent for both sides of a transaction under Colorado law. So in that situation, they're better served if they have hashed out kind of the terms of the transaction and they just need guidance to get them through the transaction, but they don't want a brokerage relationship established. They should really just go to an attorney. And granted, the attorney is going to represent one side, but if all they want is a contract drafted, that's appropriate for an attorney to do. Or if they want to be represented by a broker, then each side should be represented by a broker. But me having a close relationship with both should not be the person doing that.
And I see that we're getting very close to time, but let me ask you one last question. So if we sell as a team, who is supposed to sign the contracts? Can one agent sign on behalf of the whole team, or do we need to have every team member listed and sign the contracts?
So one broker can sign on behalf of the team.
Okay, I see that we are like straight up at 2 o'clock. And I apologize to everybody whose questions that we could not get to. I appreciate everybody participating fully and getting us questions ahead of time and just now. Gary, do you want to say anything about where this slide will be, or where the slide deck and the recording will be available?
Sure. It takes a little bit for us to get the recording finalized, and we're also going to put together some FAQs on the general questions that came in. So we'll have that all together in one place on the website.
And for everybody to know, so we had committed to doing 4 of these. This was installment 2. So the third one, we haven't determined what topics we're going to be doing yet, but we're probably going to manage it similarly to this one, where you'll be able to register, and when you register, there is a survey, so you can submit questions ahead of time on whatever topical areas we're addressing. So just keep that in mind, because I know when we first sent out the registration, I think we only had like 30 people ask questions, but then the second go around of when we sent out kind of the push notification about the registration, that's when we got a lot more questions. So if you've got some burning issue that you would like to have an answer for, that is probably the best forum in which to submit it if you're going to listen to one of these webinars. But thanks for signing up for it. And with that, I think we're done.
Yes.
Thanks, everybody. Take care.
Thanks.
Stay healthy.